So yesterday was the second reading, as I think everyone is aware of the Police Crime Sentencing and Courts Bill, shorthand PCSC Bill, and it was a very good debate, actually. The main aspects of the bill prior to the debate that were covered in the media have related very much to protests. That's been the thing that's dominating. And so this meeting will be a chance to reflect on other aspects of the bill which haven't had so much attention. Some things were mentioned yesterday, and hopefully those will get picked up on, particularly in relating to policing, sentencing, and unlawful encampment. I had a meeting earlier this year which focused on sentencing. Some of you might have been present at that. And given my role as Anglican Bishop for Her Majesty's prisons in England and Wales, I and others raised concern about clauses which would in particular see people serving longer sentences. And at that meeting, I became very aware of the Criminal Justice Alliance and the work that they have been doing, along with a coalition of other alliances and organisations, particularly in analysing and critiquing the equality impact assessments of the bill. As I'm sure people are aware, equality impact assessments are documents produced as one means of showing a government department or other public body has actually paid due regard to the public sector equality duty to eliminate discrimination against people with protected characteristics as those are defined under the Equality Act. It's a really important lens for us as peers to be looking through as we're going through the process of scrutinising this legislation. So I'm delighted that we have a whole host of expert speakers on this call today who will highlight their particular concerns coming from their expertise about the potential of the bill to entrench racial inequality in our criminal justice system. That's really concerning. So as I've said, with my role with prisons, this is something I feel very passionately about. I commented on it very briefly yesterday because there was a whole load of things to comment on in that second reading yesterday. But actually, to help us set the scene, I want to pass over to Nina Champion, who is the director of the Criminal Justice Alliance and will be known to a number of you. So Nina, thank you for setting this up, and over to you.
Wonderful. Thank you, Bishop Rachel, and thank you so much again for introducing this event, but also for your comments yesterday in the second reading. It was great to have that mentioned at the outset, and I hope that there'll be more discussion in committee stage and that this event will help with that. Just quickly on the Criminal Justice Alliance, we're an alliance of 160 organisations working right across the criminal justice system, all with the same aim of having a fairer and more effective criminal justice system. In March this year, the Criminal Justice Alliance and over 70 organisations and individuals signed an open letter to the Prime Minister calling for the government to withdraw the discriminatory clauses of the Police Crime Sentencing and Courts Bill and consult with organisations representing Black, Asian and minority ethnic communities. The sentencing aspects of the bill were introduced without any consultation because it was a white paper. Although the encampments and serious violence reduction orders were consulted on, the government ignored concerns raised about indirect discrimination and increasing racial disparities. Unfortunately, so far, no changes have been made to the bill to withdraw the discriminatory clauses, despite our letters, petition, and attendance at subsequent meetings with the Secretary of State, where we and many of the people on this call who are speaking have continued to raise our concerns about entrenching racial inequality. And the government justifies introducing discriminatory clauses by claiming that legislation will protect the public, but admits that there's limited evidence that the bill will reduce crime. Instead, our analysis is that some of these clauses could actually increase reoffending, as imprisoning more people will result in more violence and self-harm in prisons and fewer resources available for rehabilitation. And the government's evidence and their own research shows that the public often underestimate the severity of sentencing and can be relatively lenient compared to actual sentencing practice when asked to give a sentence, for example, on a hypothetical case. Earlier this year, myself and three academics posted a blog in Politics Home summarising some of the points that harsher sentencing is not smarter sentencing, and I'll share that link on the chat after I finish speaking. Another issue that we've been concerned about as a group is that none of the equality impact assessments relating to this bill look at the intersection of race and other protected characteristics such as ethnicity, religion, sex or age. And that's why we've invited speakers today to discuss how the bill will impact these individuals and go through the clauses and some of their equality impacts in more detail. And the final point I want to make is that the discriminatory clauses in the bill, if voted through, will also have a cumulative impact, adding to other policy changes that are happening in the criminal justice space at this moment, which are also discriminatory, such as the use of parvus bearing in prisons, to the relaxation of Section 6D suspicion of stop and searches. So there's going to be a cumulative impact. And we know there are many people working hard in the civil service to implement the recommendations of the Lamy review, which looked at tackling race disparity in the criminal justice system. But we're really concerned that the positive efforts that are being made risk being undermined by these new discriminatory laws that will see Black, Asian and minority ethnic people swept into the criminal justice system for longer periods of their lives. I hope you find the session useful and look forward to answering your questions. I'm now going to show a short film that the Coalition has made setting out some of our key concerns. Just going to share my screen. Okay, just going to pass back now to Bishop Rachel.
Thank you, Nina. Even just in that short film, really provocative and lots for us to think about and pick up on. So to continue this discussion around race and ethnicity, I'd like to welcome two speakers. The first is Jeremy Crook, OBE, who's the Chief Executive, Black Training and Enterprise Group. Jeremy has over 30 years experience promoting equality and inclusion, and today is representing Equal, a national independent advisory group set up to tackle racism in the UK's criminal justice system. And then after we've heard from Jeremy, we're going to hear from Greg Sproston, who is the policy manager at the Traveller Movement. They advocate and work with Gypsy, Roma and Traveller people to tackle discrimination and promote equality. So they're each going to speak for 5 minutes. Do put questions in the chat and we'll have the opportunity to pick up on things at the end. So Jeremy, welcome and over to you.
Thanks, Bishop Rachel. I'm going to focus on several clauses that we have particular concerns about, and I'll do that as swiftly as I can. And obviously I echo much of all of what Nina said at the introduction. Some of the clauses we're particularly concerned about are Clause 78 and Clause 87 that regard out-of-court disposals and will require a guilty plea. The Lamb Review already found that BAME groups are less likely to plead guilty and therefore less likely to benefit from out-of-court disposals. The government has said to CJA and Equal that they are discussing the retention of the use of the existing non-statutory disposal, namely community resolutions for lower end offences, which do not require formal admission of guilt, but rather an acceptance of responsibility. These discussions are welcome. However, we would like to see the removal of the need for an admission of guilt from a diversionary and/or community caution. Clause 107, adult must serve 2/3 of their sentence in prison and only 1/3 in the community on licence. This will mean less time on licence and longer periods of imprisonment for BAME groups who are more likely to be sentenced to a longer custodial sentence than their white counterpart. The Equality Impact Assessment acknowledges Black groups and young adults will be disproportionately impacted by this. Increasing the time in prison will also mean less time being spent supervised by the probation service after release. The government has already acknowledged that there is no evidence of deterrent impact from increasing the punitive part of the sentence. It has sought instead to justify them based on crime prevented during a longer period in custody. However, this will be undermined by a reduction in the rehabilitative part of the sentence. More time in the community generally is better for effective resettlement while on licence. The EIA states that in our view, this will not affect rehabilitation, however, provides no evidence or reasoning for that substantive view. That's a theme throughout the government case, is the lack of evidence to support the claims in the EIAs that they produced. Clause 101, relating to minimum sentence for repeat offence involving weapon or bladed article and drug trafficking. Repeat knife offences are often linked to fear and the need to protect in terms of the views of young people. Young Black men face longer periods in prison as a result, with no evidence it will increase the deterrence or reduce crime. The Equality Impact Assessment admits that this will disproportionately impact people with protected characteristics, since they may be more likely to be given a custodial sentence and serve longer sentences than before. The Ministry of Justice analysis shows that Black women are about 25% more likely than white women to be sentenced to custody at Crown Court. Disproportional outcomes are particularly noticeable for certain offences. For every 100 white women sentenced to custody at the Crown Court for drug offences, for example, 227 Black women received custodial sentences. Moving on to clause 141, serious violence reduction orders, which Nina outlined. This allows courts to make a serious violence reduction order against those who are convicted of offences involving knives or offensive weapons. Police officers will have the power to stop and search a person subject to an order to look for knives or offensive weapons, and individuals can be subject to this for between 6 months and 2 years, and this can be renewed indefinitely, in which time they run continuously whenever the person is in a public place. The breach of a serious violence reduction order can result in up to 2 years of imprisonment, an unlimited fine, or both. SVROs can also be imposed lawfully where a person does not use or have possession of an offensive weapon during the commission of an offence, or more than one person is involved and that person ought to have known that another person was in possession of an offensive weapon. SVROs aim to expand stop and search powers for people who have been convicted of an offence without the need for any reasonable suspicion. This is a drastic extension of suspicionless stop and search powers, which are currently limited to 24 hours in a restricted area under Section 60 of the CPO Order Act, to 24 months and beyond with SVROs. This is the latest in a line of recent civil orders, which can be given on a lower standard of proof than in a criminal court, such as knife crime prevention orders and criminal behaviour orders. There could also be adverse consequences to the implementation of this new power, which might make people and communities less safe. For example, it will disrupt a person's rehabilitative journey by encouraging officers to continuously stop and search an individual even after they have made a commitment to change their lives. This labelling and stigmatisation could reinforce negative stereotypes and cause harm and trauma, potentially drawing them back into a life of crime rather than away from it. I think my 5 minutes is up there, Bishop, so I won't go on because our colleagues have got to speak as well.
Thanks, Jeremy. And sorry you've got light issues, so thank you for dealing with that as well. We'll let you get up and wave your arms around to bring your lights back on. So, Greg, over to you to introduce yourself and for your 5 minutes.
Yeah, thank you for your time. So I'm Greg, the Policy and Campaigns Manager at the Traveller Movement. We advocate, as Rachel has said, for Gypsy, Roma, Traveller people here in the UK. I'd just like to start actually by just a little bit of contextual info, because I do feel there is perhaps a certain ignorance of the position of GRT people within the criminal justice system. It's estimated that about 5% of the prison population is people who report as GRT. And that's 11% of children in secure training centres and about 6% of children in young offender institutes. That's relative to GRT people being about 0.1% of the population. So there is a significant problem with overrepresentation. If I can just actually go about this in a slightly reverse manner and talk specifically about the impact assessments that have been done rather than specific clauses of the bill. I will come to a particular clause later on. I think there is a sense, at least in our organisation and across the sector, that there is no real material evidence to support a lot of the claims that have been made for the necessity of some of the clauses in this bill. Evidence seems to be being used selectively, the use of sort of exceptional circumstances to justify wholesale changes to the legislative status quo, which is quite alarming. There's different arguments within the impact assessments. In some instances, the government argues that their discrimination, which they acknowledge, is justified because it's a means to the government achieving its legitimate aims. In other areas, they're arguing that if their aims are justified, that is proof that discrimination actually won't occur. It seems like a very muddled approach. Which I think is slightly reflective of the fact that this is not very good legislation, and the civil service has obviously had quite a lot of difficulty trying to put together these impact assessments. There is a consistent theme throughout the impact assessments with regard to the lack of sort of rigorous assessment because of no usable data. This is something that we have campaigned and worked on for a number of years. In 2020, the Home Office have at long last agreed to roll out collection of ethnicity data at the police force level according to an 18+1 principle, which allows for much greater disaggregation of ethnicity data than the current system of grouping by the 6 much broader, wider ethnicity categories. Currently, only about 18 police forces are doing this. This will be mandatory from next year. We still do have concerns about whether police forces will have the capacity or the ability to record in such a way, and also concerns about whether the community will feel confident in disclosing their ethnicity data. A lot of this is reflected in the fact that the impact assessment, in our view, is incredibly weak and doesn't provide any comfort at all to the community going forward. If I can speak specifically on clause 61C and D, Jeremy's already mentioned 78, 87, 109 and 110, and I'd just like to echo his comments on that. They all apply to our community as well and are causes for concern. But with regard to clause 61, it will have a catastrophic impact on travellers' on the traveller way of life, the nomadic traveller way of life. It has been established as a legal principle for over 500 years, for longer than the Union has existed, that trespass is a civil tort. There has been a minor change to that in 1994 that made it a criminal offence with regards to certain sites, for example, railway depots but this certainly is the most wholesale change that we've seen, and given its constitutional importance, it really should stand on its own as a separate legislative proposal. Really, it's one that we would still reject, but nevertheless it is so significant that it seems unreasonable to sort of tack this on to a broader bill. Yesterday, Baroness Whittaker made the excellent argument in the debate that this particular clause is incompatible with Article 8 of the Articles 8 and 14 of the European Convention on Human Rights. That's also our view. We believe that there is settled precedent in case law with this regard in Chapman versus the UK at the European Court of Human Rights, and the London Borough of Bromley versus London Gypsies and Travellers and others, 2020 and 2001 respectively. Essentially, if that bill goes through, we would expect that there would be significant legal challenges. We would look to be part of that, but that's really the key element that we cannot have in this bill, because it simply precludes travellers from being able to live their life in the way that they see fit. I will wrap it up there because we're on 5 minutes, but I will be forwarding a little bit more information on to me that can be shared with attendees afterwards. Thanks very much for your time.
Greg, thank you. I'm aware that with everyone who's speaking, there's so much that we want to pick up on. So I hope we'll have some rich discussion at the end and, of course, going forward. We now have two speakers who are going to talk about the intersection of race and age. I'm delighted that we have Pippa Goodfellow, the Director of the Alliance for Youth Justice, who's got over 15 years experience in policy, research and communications, with a particular focus on children in the criminal justice system. Then after Pippa's spoken to us, then we'll hear from Laurie Hunt, who is the Criminal Justice Programme Manager for the Barrow Cadbury Trust and is here today representing the Transition to Adult Alliance. Prior to that, he was actually at the Ministry of Justice working on the Lammy review. So Pippa, look forward to hearing what you have to share now.
Thank you very much, Bishop. Can everyone hear me okay? Yeah, excellent. So thank you for the introduction. Yes, I'm here to just run through some of the particular concerns that we have at the Alliance for Youth Justice in regard to children and the youth justice system, and why it's important to consider them in the context of racial equality, or should I say racial inequality. So the Lammy review in 2017 highlighted racial disparity in youth justice as its biggest concern. And the youth justice system continues to present shameful racial and ethnic disparities. Children from ethnic minorities are over-policed, more likely to be stopped and searched, arrested, less likely to be diverted, and are therefore disproportionately likely to end up in the criminal justice system. And racial discrimination and bias are also evident in sentencing decisions for children. According to Youth Justice Board research, children from ethnic minorities are more likely to be given a custodial remand, and in almost all cases, Black, Asian and mixed ethnicity children are more likely to receive harsher sentences. And this is demonstrated by the fact that Black, Asian and minority ethnic children now represent over half of children in prison. And that is a development since David Lammy wrote his review. That's compared with only 18% in the general population. And the criminal record system further exacerbates and perpetuates those racial inequalities. So all measures that have a damaging effect on the youth justice system have a particularly damaging effect for children from racially minoritized groups, because they're already significantly overrepresented. And surely getting it right for children in contact with the law will have a beneficial effect in terms of how that plays out in terms of their entry, or hopefully not, into the system as adults. So it's key to stopping the vicious and unjust cycle of discrimination. So I just wanted to touch on some of the punitive sentencing measures in the bill, and many of which that have already been described. So Black and minority ethnic children will be disproportionately impacted by any punitive measures. And of particular concern, they're more likely to face harsher sentencing regimes set out in clauses 101 and 104 to 107, which increase the use of mandatory custodial sentences and increase minimum custodial sentences and terms. As we've heard, and as has already been said, the government thinks that this disproportionate impact justifies itself because it's a proportionate means of achieving a legitimate aim. But there's no evidence that increasingly punitive sentencing deters crime or reduces reoffending, and this is particularly the case for children. Deterrence relies on the awareness of sentencing, which among children is particularly low as a result of their brain development, the prevalence of mental health, learning and communication difficulties and trauma, and particularly around the growing understanding around child criminal exploitation being at the heart of their involvement in crime. So the consequences of these reforms will mean that more Black and minority ethnic children are sentenced to custody and spend significantly longer while they're there. Unjustifiable, given that there will not even be any resultant reduction in crime. I just wanted to talk about those sentencing measures in the context of some of the rest of the bill in relation to children, and just to back up a lot of what has been said, and I know is due to be said by other speakers. Around serious violence duty, we're particularly concerned about the impact that this will have on Black and minority ethnic children because it's police-led and enforcement-driven, so it's likely to play out in a similar way to the gangs matrix and the prevent duty, where racialised profiling, labelling and targeting is rife. We're concerned about the provisions to increase the sentence for an assault on emergency workers. While we understand the importance of protecting emergency workers, we're concerned about reports of police unfairly using the offence with racialised and over-policed communities, as well as the offence arising due to children acting out of the frustration that they feel of unjust targeting by the police. I would echo what's already been said in terms of the provisions in clauses 61 and 63 around unauthorised encampments and the criminalisation of trespass and the particular impacts that that will have on children in the system. And I think it's really important to see this in the context of other reforms, such as 20,000 extra police officers and the introduction of knife crime prevention orders. And just to finish on a brief, unfortunately brief, positive note, we do welcome the reforms to custodial remand in clause 132, which are crucial in terms of tackling racial disparity, and also the reforms to childhood criminal records. But a full review is required in order to address ongoing barriers to education, employment and other opportunities, and to bring about a distinct approach for children. So the government has stated it wants the bill to improve trust and confidence in the system, but in fact, these measures represent a missed opportunity to stop a cycle of discrimination and mistrust by treating this generation of children differently. Thank you.
Pippa, thank you. We're going to hear now from Laurie, and then we'll switch the recording off and have the opportunity for some Q&A. So Laurie, over to you.
Thank you very much, Bishop Rachel. So my name is Laurie Hunt and I work for the Barrow Cadbury Trust. We focus on young adults in the criminal justice system. We make the case for a distinct approach based on neuroscience, that the brain is not yet fully formed until the mid-20s. This, along with sociological and criminological evidence, demonstrates that an approach tailored to young adults' developmental stage is required while they are in the justice system. There has been an overall decrease in the number of young adults in the justice system, but the reduction has predominantly benefited white young adults. BAME young adults, Black, Asian and minority young adults, are disproportionately represented in the young adult age group. Information from the Ministry of Justice shows that the number of prisoners under 25 has decreased since 2014. But the proportion of BME prisoners under 25 has increased. In 2014, it was 33% compared to 41% in 2018. This is almost on a par with the disproportion in the youth justice system. T2A, in collaboration with Revolving Doors, have done some particular research on Black young adults who commit revolving doors type offences, that is relatively minor non-violent offences. They are now 47% less likely to receive a community sentence and 81% more likely to receive a custodial sentence than they were a decade ago. We are concerned that the PCSC bill does not take into account the evidence we have on continuing maturity. We are concerned that lengthening periods in custody during the crucial period of brain maturation and the formation of identity will have a detrimental effect on public safety. Spending longer sentences in prison at this stage of a young person's life will not help them develop positive identities and move away from future criminal behaviour. Most young adults, including those who have committed serious and violent offences, do stop committing crime in their early 20s. And in fact, this is demonstrated in the government's own evidence in its serious violence strategy, which shows that even for individuals classed as high offending, the peak age of violent offending is 19, and this declines significantly from the age of 21 to 24. The government does not appear to have recognised that the effect of increasing the custodial portion of a sentence has a corresponding impact on shortening post-sentence probation supervision, which will impact on young adults particularly as they need to mature and grow out of crime and need the support to build positive adult identities. Today, the Scottish Sentencing Council announced that it will be submitting to the High Court sentencing guidelines for young people. It requires courts to have regard to rehabilitation as a primary consideration in sentencing young people, including young adults, recognising their greater capacity for change. The Council considers that this will help achieve one of the guidelines' key aims to reduce offending among young people. This document is particularly welcomed by the Transition to Adulthood Alliance and stands in stark contrast to what is proposed in the PCSC Bill. To summarise or to relate to these clauses, what I've said back to the clauses in the bill, T2A supports amending clauses 106, 107 and 108 so that they do not apply to people under the age of 26, and striking out clause 100 and 104, which relates to the starting points for murder when committed at the age of when under the age of 18. I'll leave it there. Thank you very much for your time.
Thank you. So we're now going to continue with our next tranche of speakers, and I'd like to welcome Lauren Nichols, who is the Senior Project Manager for the Criminal Justice Programme at Maslaha, which seeks to change and challenge the conditions that create inequalities for Muslim communities. And in her previous role at Clinks, Lauren authored a report called Time to End the Silence, which looked at the experience of Muslim people in prison. So we'll hear from Lauren, and then we're going to hear from Maithi Rajesh Kumar, who is the Policy Manager at Agenda, the Alliance for Women and Girls. And Maithi's worked in the non-profit sector for 10 years, not only in the UK, but also in India and Sri Lanka. And in 2017, Agenda published a report called Double Disadvantage, which highlighted the experience of Black, Asian and minority ethnic women in the criminal justice system. So first of all, Lauren, and then we'll come to Maithi.
Thank you. So I wanted to just start by providing some context around the treatment of Muslims in prison to understand the kind of environment that this bill will be implemented in and the impact that it could likely have on the Muslim community. So the number of Muslims in prison has more than doubled in the last 15 years. So they now are significantly overrepresented. They make up 17% of the prison population compared to just 5% of the general population. But the disparities aren't just a numbers issue. In terms of treatment and experience, Muslims report significantly more negatively in their treatment by staff and their experience in prison compared to non-Muslims. A combination of media portrayals, decisions and policies to combat radicalisation and responses to terrorist attacks have shaped with an intense pace how Muslims are perceived in wider society, but also in prison, particularly with the increasing focus on radicalisation concerns in prison. It's had a massive impact on the way that Muslims are perceived within the prison estate. At Maslaha, we've conducted our own research on the experience of Muslims in prison, and it revealed what the level of impact that this climate has had on their treatment and the discrimination that Muslims face, and how pervasive stereotypes are within the estate that associate Islam with extremism. It's led to Muslims being seen through a lens of terrorism and risk, to the point where unofficially Islam has in many ways become to be seen as a risk factor rather than religion as a positive aspect in a person's desistance journey. Muslims we spoke to felt stereotyped as more at risk of radicalising or being radicalised, and they faced heavier scrutiny in prison. And whilst many would turn to religion as a source of comfort and stability, this was seen negatively by the prison system, something to be wary of, and a potential sign of a radicalisation journey. In particular, because of a lack of understanding of Islam and its traditions, we often saw stereotypes forming the foundation of how Muslims were perceived. So behaviours of that Muslim prisoners displayed, for example, activities like praying out loud or praying with each other, the way they dressed, learning Arabic, were seen as potential signs of radicalisation and misinterpreted in that way. We also know that Muslims are more often described being split up on prisons and being kept apart, with concerns over the effects of having, in essence, what's perceived to be too many Muslims in a space. And it's important to bear in mind the reality of terrorism convictions in all of this. In reality, only 1% of Muslim prisoners are convicted of terrorist offences. And the reason I bring up this context is because it's relevant to the way this legislation has been developed at speed, and in parts of it in response to terrorist incidents that have happened over the last couple of years. And because of this environment and the stereotypes and scrutiny that Muslims face in prison, they stand to be disproportionately impacted by some of these clauses. In particular, I want to draw attention to clause 109, which provides the power to prevent the automatic release of a prisoner serving a standard determinate sentence, and instead to have their case referred to the parole board to make a decision on their release. So it's really important to note that this is for people whose original offence did not meet the threshold for parole board intervention. And it means that people serving sentences for non-terrorist related offences can be held in prison as for posing a potential, for being deemed to pose a potential terrorist threat if there's concern they've become radicalised in prison. And it can also apply to people who are deemed to potentially pose a threat of serious violent or sexual offences on release. But this is de facto sentencing on the basis of alleged behaviour that has occurred after the original offence, and crucially after the trial for the original offence. By enabling this kind of retrospective sentencing, it bypasses the judicial process and all the protections that should provide somebody, and the long-standing principles that of having evidence tried and tested in a court, and the opportunity for the accused to have access to a legal defence. And it can therefore lead to people being kept in imprisonment disproportional to their original offence, and on the basis of vague, undefined and intangible concepts of risk, particularly when we can see how risk is highly racialised, and how Muslims and Black and ethnic minority people are subject to racial profiling. The criteria for which these cases that should where this power should apply, and the evidential test and standard of proof required for invoking this power, is also incredibly vague at this stage. There's no clear mechanism in place to control its use. We're expected to trust that the application of these powers will be rare, but the criteria itself is very broad, and no mechanism to guard against abuse of these powers or prevent them from being used more widely. The Home Office recently released an equality statement, which shows that they don't actually have the detailed data with regards to religion for how prisoners will be impacted by this. And but they do acknowledge that BAME individuals are overrepresented in the group who will be where this power may apply. Yet despite the lack of data, it's concluded that they do not consider that anyone will be treated less favourably because of protected characteristics. And how they can make that conclusion without the available data is beyond questionable. It also does acknowledge that those that will fall foul of this power is likely to reflect the focus of counter-terrorism measures in the UK more broadly. And as we can see, the government has already shown high concern about Islamist ideology and Islamist terrorism being the focus of those strategies. So this will mirror into the use of this power. And we'll see a disproportionate focus and scrutiny on Muslim communities. There's a clear risk that, unconscious or not, bias will affect the decision-making behind this power, that those who appear Muslim or are practicing Muslim will be unfairly assessed as presenting a danger and a risk of being a terror threat. But labelling someone a terrorist will have a significant impact on an individual's life and their freedoms and the stigma that follows them. So any public protection concerns must be founded on evidence, and that must be tried and tested, not uncorroborated opinion or racialized risk profiling and left to the parole board decision-making process. Ultimately, keeping someone in prison, as has already been highlighted with regards to the other clauses, will reduce the amount of time they spend with probation. It will impact their desistance journey and their motivation throughout their sentence. So if anything, is likely to have a counterproductive impact on future reoffending. There's no evidence that these provisions will make the public any safer or have an impact on serious or terror-related offending. And there's a clear risk that it poses to people's right to fair trial, that there's too much potential for these powers to be abused and to disproportionately be used against minority groups. And for that reason, we recommend at Maslaha that this clause entirely and the changes proposed by it be scrapped. I'll stop there.
Thank you very much, Lauren. So we'll come now to Maithi.
Hello, everyone. So just want to echo what so many of my colleagues have said about lack of evidence and sort of lack of rigorous assessment. I won't go into loads of detail because all of you have covered it so well. So I'm going to talk specifically about Black and minoritized women who are consistently overlooked in policy and in practice, as a minority within a minority in the criminal justice system. So already women are a minority, and then Black and minoritized women make up small numbers and therefore are often overlooked. Experiences of gender-based violence as well as racism and xenophobia shape Black and minoritized women's journeys into the criminal justice system. However, we know that system responses repeatedly ignore the ways in which living in the intersections of faith, gender, ethnicity and class impact on these women. And as Nina said, the impact assessments continue to ignore this and continue in this vein, which is very, very concerning. So just for a little bit of context, approximately 17% of adult women in prison are from ethnic minorities compared to 14% of the general population. About 9% of women in prison are Black, 5% are Asian, and 4% are from a mixed ethnic background. Of all women sentenced in 2019, Black women had the highest custody rate at 23%. So we know that the bill, we think, will fundamentally undermine the government's own ambitions of reducing reoffending and creating safer communities, as they've themselves outlined in the National Concordat on Women at Risk and the government's female offender strategy. The government's female offender strategy acknowledges that there, as they say, are unique challenges for Black, Asian and minority ethnic and foreign national female offenders in the criminal justice system, both in custody and the community. And they say this is why we'll be looking closely at what further action can be taken to identify and address needs specific to these groups. So this is what they say. However, the government's impact assessments and statements do not consider at all the intersection of race and gender on its sentencing policies, including in the bill, which is a really missed opportunity. And it also fails to address the intersection of race and age and of race and religion as well. So I'm just going to talk about key sections in the bill, which we highlight will disproportionately affect Black and minoritized women, although agreeing what has been said already around the kind of widening net effect that will happen. So specifically talking to clause 2, which Pippa alluded to, around the new proposed increase in sentence length for assaults on emergency workers from 12 months to 2 years. And we see that this is going to have a detrimental effect on Black and minoritized young women. It already makes up a staggering 17% of total offences leading to a custodial sentence for Black young women aged 18 to 24, compared to 6% for their white counterparts. We know assaults on emergency workers are serious and should not be accepted as part of the job. However, frontline staff who deal with severe and complex problems are not always equipped and adequately resourced to identify and respond to the challenges facing women. So we spoke to a young woman, Nia, who is supported by Muslim women in prison, who was charged with assaulting a police officer. And just to put it into context about her experience, she told us, it's like you assaulted a police officer, you're a criminal, but when you look at the rest, that's just the tip of the iceberg. There were like 4 or 5 police officers and I was crying. I just tried to kill myself and being beaten up by my family really badly. And then the police said, you're going to get arrested. So we see how this plays out for a young woman who's already experienced severe trauma and abuse and who's re-traumatized in that situation and then arrested. We know that increasing the sentences for these crimes will not keep frontline workers safe. There is no evidence that says that that will be. Young women like Nia are often reacting under extreme stress, frightened and on high alert. Instead, staff should be given proper training to recognize the signs of trauma and distress and respond in ways that de-escalate the situation, not make things worse. And she told us that if they had just backed off a little bit, I think I would have reacted differently. Prison simply isn't the place for this women. The next clause I want to speak, so we say that the assaults on emergency workers to be increased should be scrapped. And the next clause I want to speak on is on serious violence reduction orders. Already quite a lot has been said, but we're particularly concerned at how it will negatively impact young women experiencing criminal exploitation, leaving them facing up to 2 years imprisonment because they ought to have known someone in their company was in possession of drugs or weapons. And we're really concerned that this is particularly going to impact Black young women who are significantly more likely to arrest than white girls. These plans should not move forward at all until data relating to women and girls offence types are broken down by ethnicity and they're analysed and reported on, and the ought to have known provision is removed. We are concerned that this clause is in the vein of joint enterprise laws, which are known to have already brought women into the criminal justice system that had no involvement in the alleged offence. And research has found that in 90% of joint enterprise cases against women, that they had engaged in no violence at all. And in half the cases, they were not even present at the scene. So we are really concerned of what this bill is going to do. And we also know for many women, speaking out simply is an option as a result of the abuse and control they're experiencing. And despite the government's own commitment to tackling domestic abuse and recognition of coercion and control, this bill actually completely ignores those dynamics and is kind of conflicts with what the domestic abuse statutory guidance is talking about. And then just very quickly about what's not considered in the bill, we're really concerned about the impact of children. We know that as many as 95% of children are forced to leave their home when their mother goes to prison, who is more likely to be their primary carer. The bill's impact assessment recognised that changes could have a negative impact on families as they would be apart from longer. We're really concerned particularly about single mothers, and we know that this is going to have a disproportionate impact on Black African and Black Caribbean families, as they are more likely to be headed by lone parents as well. So in summary, we are really concerned that more Black and minoritized women will be failed by the justice system as they're met with punishment and stigma when what they really need is support. We have to see investment in specialist services that are led by Black and minoritized communities that support these women who've experienced extensive abuse, trauma, and other adverse experiences, support them before they reach crisis point to help prevent many of these offences occurring in the first place.
Thank you, everyone. I just want to say huge thanks to all our speakers. We've in many ways just had a little taster of some of this today, and I'm sure it's provoked lots of questions and reflections. It certainly has in me. I guess one of the big things that's come up again today that came up in the second reading yesterday is why? Why have we got this bill? But we have, so we have to work with what we have. I think we do have to continue to work very hard in all our amendments to fight some of the populist narratives out there, which have been responsible, I think, for a lot of the clauses that have ended up in this very large bill. I think we have to work hard at doing join up. A number of speakers have spoken about whether it's existing pilots, whether it's the female offender strategy, whether it's work that's been done in the past, and how we actually stitch that together and listen to that. Because again, one of the things I've heard really clearly this afternoon is something that I spoke about yesterday, which is what we do has to be based on evidence, has to be based on research. And there's lots of that already exists that we mustn't ignore. And if there are other things that are being tested out, then we need to have those pilots and have the evidence from them and know what it is we are trying to do. I think the other thing I would say that's come out this afternoon is there's often, I think, a very simplistic view which talks about victims and perpetrators. And actually, we know that so many people who are on the end of this bill about committing crime are victims themselves and have lots of prejudice against them. And again, we have to look at the complexity of this and not to be having knee-jerk reactions. So I want to say huge thanks to all our speakers. Those of you who are watching it live or who are watching the follow-up recording, please do be in touch with Nina Champion, who has pulled this together, who can then in turn put you in touch with speakers and the various organisations so that we can be sure when it comes to amendments, we are working well and in an informed way to do what we can to work with a bill to make it as good as it can be, and to remember that we're talking about people here and not just theories. So many thanks, and thank you to all of you for participating and for those who've taken part in this. Thank you.